Hi, everybody. Hopefully everybody can hear me okay. Thank you all for joining us today. We're looking forward to getting started. Just a couple of quick housekeeping notes before we do. For the benefit of all participants, attendee lines are muted. So if you have any questions that you would like to submit during the event, you can submit them through the question and answer space. If we cannot get to your question during today's webinar, we will follow up with you after the program. Please also note that today's webinar is being recorded and will be circulated to all registrants via email after the event. If you have any follow-up questions at that time, you can also reach out to any of the key contacts listed on that email communication. Note that Dentons can only issue CLE credit for attendance during the live broadcast of the webinar. So participation on the live webinar must be on a computer or a laptop device. Credit is not available for joining via a mobile device. One other important note, if you have a New York, New Jersey, Pennsylvania, or Kansas license, please be sure to listen for the code word given during the program. When prompted, you'll need to enter that code into the Q&A and of section of the screen. And if you don't have a license in these states, you can disregard this. So with that in mind, I think we can go ahead and get started. So thanks everybody for joining us today during our discussion about the legal framework of pregnancy and parental leave in the United States, as well as some recent developments in that framework. We have a lot to get through today, so I'm going to jump right in. My name is Samantha Cook. I'm an associate in the Pittsburgh office at Dentons, Cohen and Grigsby in the Labor and Employment Group, and I'm joined by my colleagues Sandy McCandless and Ann Kendall. So if Sandy and Ann, you wouldn't mind briefly introducing yourselves for the participants.
Thank you. I'm Sandy McCandless, an employment and labor partner at Dentons in the San Francisco Bay Area. Our team represents employers in all aspects of employment, from counseling and contract drafting to defending agency proceedings and class actions in individual litigation. Our Dentons practice is also global, facilitating employment work for employers in the other countries outside the U.S. in which they operate. I'm very glad to be with you virtually today.
Hello, I'm Ann Kendall, and I'm with the Dentons office in the Des Moines, Iowa location. I've been in practice for about 25 years, similar practice to Sandy's practice. Our group does similar work. I've been mostly in employment and commercial litigation my whole experience. However, I was general counsel for 3 years at the nation's largest privately owned printing company. So I do have a little bit of the in-house experience as well. And also glad to be with you today.
Thank you to you both. We have some wide geographic diversity here, and that's important. And Sandy's going to educate us a little bit more later about some of the state and local laws impacting pregnancy and parental leave. But as you can see, we have a lot to cover. The goal today is not to get into the super nitty gritty of leave entitlements and things like that, but it's to sort of show how all these puzzle pieces sort of connect and where the gaps in pregnancy and parental leave law have been historically, and how recent legislation is starting to fill those gaps in. So you can see here all of the various federal laws that sort of come into play, as well as state, local law, as well as voluntary leave entitlement, voluntary leave policies that employers may choose to offer to their employees. And so hopefully we'll leave you with some takeaways and some best practices that we've seen in our time practicing and representing employers and assisting them with drafting their policies and administering them. And if we're lucky at the end, we'll have time for questions, but that seems unlikely. So again, feel free to enter questions in the chat as they arise, and we will get back to you. So just very, very briefly, why are we talking about this? That's probably obvious. This is always a timely issue. As of last year, only 27% of private industry workers in the United States had access to paid family leave, while 89% had access to unpaid family leave. And Ann will fill us in on that, why that is likely true. But it is pretty well known at this point, the U.S. is really one of the only wealthy nations that does not have a universal paid family or parental leave law. And I don't think that's any ill intent. I think it's just because there's been a sort of a patchwork of legislation and regulations over the years to make up the legal framework that we have today. And so that's really what drives employers' pregnancy and parental leave policies, which is why it can be really challenging to draft them and make sure that you're complying with all of these various laws at the federal, state, and local level that might impact your policy. This is just a visual to kind of give you an idea of all of those different elements and how they start to fit together. We'll talk about some of these in more detail, but just as an overarching principle, there are a lot of aspects at play when you go to draft your policy and when you go to actually administer it and answer your employees' questions about, well, when can I take time off? And can I take time off before FMLA? And, what if I need additional time off while I'm pregnant? And those sorts of questions. And so this is just a very, very high level overview of those pieces. So I'm going to hand it over to Anne to sort of give us some of the basic backbones of pregnancy and parental leave in the U.S.
So as Sam kind of teased, probably the bulk of the unpaid leave probably comes from the Federal Family and Medical Leave Act, which provides for unpaid leave for employees who have a serious health condition, or more importantly, for today's purposes, for the birth of a child. And we also want to talk a little bit about placement when we're talking about policies as well. But the key thing is, and we're not, going to read all the slides to you, we want to be cognizant of time. The slide kind of lays out some of the basics about what employers are covered, what employees are eligible. Not every single employee is eligible. And then what are the benefits that are provided? Generally speaking, when we're talking about, pregnancy, or birth of a child or placement of a child, we're talking about 12 weeks. There are different provisions under the FMLA for other things that we're not talking about today. It does provide for, continued health coverage. However, employees have to pay for that coverage while they are on FMLA leave, and it does provide for job protection. A couple other things to note. Normally, when we think of pregnancy and maternity leave, we're thinking of that block of leave that happens after a child is born, which can be for, as I mentioned, birth or placement of a child. That leave is traditionally a block. It's not intermittent leave, which are smaller chunks of leave, unless the employer wants to agree to that for some reason. And there can be some reasons for that after the fact, but that's not an obligation of the employer. Prior to birth, there can be need for intermittent FMLA leave, for example, for doctor's appointments and things like that. So just making sure that that's on your radar and that you're cognizant of that. Next, we'll talk about the Americans with Disabilities Act, which is another federal law that provides for some concessions for employees. This one focuses specifically on people who have disabilities. The FMLA, we're talking about serious health conditions, and then there are other things covered under the FMLA, for example, birth or placement of a child. The Americans with Disabilities Act, focuses largely on that person's ability and whether they can perform the essential functions of their job with or without reasonable accommodation. So a person with a disability may not need an accommodation and can perform their job just fine. A person with a disability may need an accommodation. And if it's a reasonable accommodation that allows them to perform the essential functions of their job, then that is an obligation that the employer has. Now, what is interesting and one of the struggles that has historically happened with our laws and with the courts is trying to figure out, how does pregnancy fit in? It's not a disability. There are limited protections under the ADA, but there are some. A person with a disability may also be pregnant, and the pregnancy may exacerbate that disability, which may trigger some need for additional accommodation under the ADA. Or, for example, someone could, have diabetes when they, are pregnant, and then that is a disability under the Americans with Disabilities Act. So again, there's some coverage, and then there's also some gaps under the ADA, and that's where the Pregnant Workers Fairness Act comes in.
While we are talking about federal statutes, we wanted to be sure to talk about Title VII. and and the Pregnancy Discrimination Act. So Title VII is very important to keep in mind when you're putting together a paid parental leave policy. It doesn't provide a leave entitlement, but as I'm sure everybody knows, at this point, Title VII does prohibit discrimination on the basis of sex and gender, which includes pregnancy. And so this can make crafting a pregnancy and parental leave policy kind of sticky because it inherently involves issues of gender and sex. And so it just has to be handled pretty delicately so as not to inadvertently violate Title VII. Companies have been found to violate Title VII when their policies discriminate against men, assuming that women want more bonding time than men, and assuming that, maternity leave is more appropriate than paternity leave. And so we just wanted to make sure we touched on this because this is still an issue that I see when I review pregnancy and parental leave policy. And so it doesn't govern how much time somebody gets, but it does govern that time does need to be equitably allotted, and policies cannot discriminate based on gender. That being said, courts have recognized, and the EEOC recognizes a distinction between time off for medical leave related to pregnancy and childbirth versus time off for bonding. And so it's really that bonding leave that you need to make sure that you're treating all parents, regardless of sex, gender, adoptive, foster. You want to make sure that they're being treated equally under your policies. So I'll hand it back to Anne.
So as we've kind of been highlighting, there's been, sort of this struggle. And so as Sam just mentioned, that, Title VII does cover that. Well, it didn't always. And so just to kind of step back for a second, what is pregnancy? It's not a disability. It's not an injury. It's not an illness. It can contain those things, but it isn't those things. And as Sam mentioned, it is related to gender because only females can be pregnant. The Pregnancy Discrimination Act from 1978, was enacted by Congress to directly address a Supreme Court case that had found that Title VII did not ban pregnancy-based discrimination. So Congress came back and said, no, we want to make sure that this is very clear, and it does. And that's where the Pregnancy Discrimination Act came into being. And as you can read, it added specific language to Title VII to clarify that pregnancy is protected. And then on the next slide, we talk about where there's still a gap. So we have the Pregnancy Discrimination Act, which makes it clear that Title VII does protect, pregnancy from discrimination, but it did not require changes in working conditions to accommodate the needs of pregnant employees. So sound familiar? That is a gap here. One thing that I think is kind of an interesting case to look at is this Young versus UPS case. Simply because it shows sort of the struggle that the court has had, as well as employers have had, in trying to balance the different types of leave that employees need, and accommodations that they need, including pregnant employees. And so there was kind of a tension or a struggle between, how this employer was accommodating, people who needed, different accommodations because of pregnancy versus they had a work comp injury, they had an ADA issue, they didn't have their DOT certification anymore. And so there was some tension and struggle there, which still left a gap, which I think probably has been largely filled until we discover another one by the PWFA.
Right, thanks. And so this is the new one, and probably why many of you joined today. This is the newest piece of legislation that's largely impacted employers' policies with regard to pregnancy and parental leave and related accommodations. And so as Anne mentioned, up until now, there's really been no law that requires pregnancy and its limitations to be accommodated, which can be challenging. Like Anne said, it's not necessarily a disability. It's not necessarily a serious medical condition. It certainly can become one, but it's not inherently a disability that would be accommodated under the ADA. So what the Pregnant Workers Fairness Act did is requires covered employers to provide reasonable accommodations to known limitations based on or related to, affected by, or arising out of pregnancy, childbirth, or related medical conditions. We're going to go through these. This is a very, very broad, and it's intended to be very, very broad language. But it still has that same sort of undue hardship consideration that you would weigh if this were an ADA issue. So I'm not going to read all of this. This will be in the slides that have been distributed to you if you want to read more closely. But essentially, high level points. PWFA applies to all private employers that have 15 or more employees. And so it's much like Title VII and the ADA in that way, in that it covers much smaller employers than FMLA, for example. It requires a reasonable accommodation, which is essentially anything, any change to the work environment or the way that things are done. And this could encompass a lot of different types of accommodations depending on the size of the employer, depending on the need of the employee and what's reasonable. So that could be anything from I need a week off, before childbirth to I need to be able to carry water around with me at work or take restroom breaks. So it's meant to encompass a lot of different types of accommodations. We're going to talk more about what it means to be a qualified employee because this is a pretty significant change from the ADA, and it might have some serious implications for the way that you sort of think about, if somebody becomes temporarily unqualified, how you accommodate them. And what is a known limitation? It's not necessarily something that rises to the level of a disability. It's a condition that is related to pregnancy. And so I think an easy example there is morning sickness. Morning sickness isn't a disability per se, but it certainly can be difficult to come to work if you're feeling sick in the morning. And so that might be an example of something that impacts a pregnant worker that's not a disability, but that may need a reasonable accommodation. The term related to, affected by, or arising out of. I just want to flag this too, because I found this very interesting that between pregnancy, childbirth, or related medical conditions, this is very broad, and it doesn't necessarily only apply to pregnant workers. It could also apply to people who recently had a child, people who recently had a miscarriage, people who are trying to become pregnant, or even in some states, subject to a dispute in the courts. Some states it might even apply to abortion and related medical care. So this is intended to be read very, very broadly. And so it's important to know that things that might not have been considered a disability in the past, you now have to think about ways to accommodate. But that being said, there's still that defense of undue hardship. If it's something that really cannot be accommodated, there are instances where the employer does not have to accommodate, but it's a pretty high burden. It has to be a significant difficulty or expense. Okay, so we are at the CLE code word now, so we'll take a pause. As I mentioned at the beginning of the webinar, if you are in Kansas, New York, New Jersey, or Pennsylvania, and you're seeking CLE credit, please make sure you type the code word disability into the Q&A section of your screen, and make sure you hit the send button so it registers. In case you missed it the first time, and it's on the slide here, the code word is disability. So picking up where we left off, leave is the reason we're talking about the PWFA is not only because it's new and it's very important, but because we're talking about pregnancy and parental leave. Leave is an accommodation that employers may need to consider in some circumstances because it's one of many types of reasonable accommodations. It could mean granting time off to go to routine medical appointments. It could also mean taking a pretty substantial period of leave either before FMLA kicks in or for employers who aren't covered by FMLA or employees who aren't eligible for FMLA. So it's very important to recognize that PWFA might expand those instances where leave is a reasonable accommodation for employees. But I also put on here, this is an important note, be careful about requiring employees to take leave. PWFA regulations are pretty clear. Leave, an employee can ask for it and you can certainly consider it, but if you're going to require it, it really has to be an absolute last case scenario where there's no other reasonable accommodation that can that can address that limitation. So just be careful about requiring leave as a reasonable accommodation. Okay, so this is sort of back to law school. We're going to do just a couple hypotheticals to illustrate these. Let's say Pop owns a small hardware store with 20 employees in Ohio. He knows he does not have to deal with FMLA because his store is too small. One of his star employees becomes pregnant and says that she's going to need about 6 weeks off after her baby is born before she can come back to work. Pop is offended. He is hurt. He wants Mandy to stay. He doesn't know what he's going to do without her for 6 weeks, even though there are other employees that could probably pick up those shifts. And he just decides it's okay if he fires Mandy because he's not covered by FMLA, so she doesn't have job protection. So is Pop right? And you don't have to think about this too hard. I think it's obvious. The answer is no. Leave, like I just said, can be an accommodation. Even if you're not covered by FMLA, even if it's 6 weeks, if that's something that you can reasonably accommodate, you have to have that conversation and you have to think about that as an option. And I also am going to just briefly touch on this because I mentioned it before. Employees, even if they're temporarily quote unquote unqualified to do their job because of their pregnancy for some reason, they may still be considered qualified under the PWFA. And so that means you can't just drop somebody because they can't, do their job for a short amount of time. PWFA requires that you look to the near future, which is actually 40 weeks is the guidepost, which is essentially meant to encompass a pregnancy and recovery from a pregnancy. So if somebody's going to be qualified again to do their job in the near future and those essential functions can be reasonably accommodated, that person is still going to be considered qualified under the PWFA. So this is just another quick example to highlight that. Let's say an employee works in a warehouse. She's able to continue to do her job for the first 6 months, but then towards the end of her pregnancy in the 3rd trimester, her doctor says you shouldn't be lifting anything over 30 pounds. She has to lift 50 plus pounds every day in the warehouse. So what's she going to do? Her doctor says, well, once you get back from, your time off, you will be able to lift 50 pounds again. She tells her boss that she can't lift 30 pounds anymore. But there's no light duty jobs or administrative jobs available. So what should the employer do? Take a moment to think about it. I think this is pretty clear too. It ties back to what we were just talking about the qualification issue. Even if the employee is temporarily not qualified, they need to think about, is there some way we can accommodate this in the meantime? Look for light duty, look for administrative positions. If none are available, maybe an unpaid leave is that accommodation. But you just have to make sure that you're thinking through whether that person can be accommodated while they're temporarily unable to perform the essential functions of that job. And then after they return to work, will they be able to do that job? Okay. Last hypothetical, I promise, for a little bit, and then we'll have Sandy give us the lowdown on state and local law. This ties back, and this may or may not be drawn from, real questions that I've gotten from clients before. So let's say a hospital employs 100 doctors and 70 of them are men. Tough scheduling, difficult shifts. Very, very important that all of the doctors remain ready and available to work. The hospital's paid parental leave policy provides 4 weeks of paid leave to the primary caregiver upon the birth, adoption, or placement of a child. So a male doctor tells the administrator that his wife is expecting a baby and that he's going to be the primary caregiver of the child while his wife is recovering from childbirth. And he requests 4 weeks of paid leave. His boss is concerned, well, if we give him paid leave, all these other doctors, every time their wives have a baby, what if they want paid leave? What should the hospital do? Is it okay to deny that request? I would say no. The primary caregiver model is a pretty common way that employers have structured their paid parental leave, that the primary caregiver gets the paid time off. And on its face, it's non-discriminatory, but in practice, it can be administered in a really discriminatory way, where sometimes HR or employers inadvertently assume that a birthing mother or a female parent is going to be the primary caregiver. And so they require the male parent or the non-birthing parent to show this extra hardship of why they need to be the primary caregiver before they give the time off. So it's just really important. This goes back to that Title VII issue we talked about before. Just have to make sure that your policies are non-discriminatory and that all parents are getting the same type of bonding leave. Again, not necessarily the same medical or disability leave, but the same bonding leave. So with that, that was federal law. There's a whole host of state and local law, which Sandy is going to guide us through.
Thank you, Sam. So, anytime you have a pregnancy or parental leave issue, it's really critical to check the state and local laws covering the employee requesting the leave. Legal compliance is much more complicated today than it was in the past, in particular with more remote work. In some cases, even two jurisdictions are implicated. For example, if an employee works in California but lives in Nevada, then the state laws of both states can come into play. Illinois employees sometimes live in Wisconsin. In the DC area, you have people living and working in different jurisdictions with two coming into play. And then there is simply remote work where the employee lives and works in a different state than others, and the state laws and local laws of that jurisdiction have to be considered. Using California as an example where I happen to live, but also where it's the most complicated state in the country, the state and local laws are very complicated. There's an interplay between them, and the employer needs to be familiar with what they are in dealing with California employees who need these types of leaves and many other types of leaves. California is often a trendsetter for what happens in the rest of the country. So let's look specifically at California state law. Pregnancy and parental leave are different. California pregnancy disability leave applies to employers with 5 or more employees and provides up to 4 months leave while the person is disabled by pregnancy. This is really critical because this is not a law that will apply elsewhere. Pregnancy disability leave runs concurrently with federal family and medical leave, but can run longer than federal family and medical leave. It's 4 months rather than 3 months. And once pregnancy disability leave is over, California Family Rights Act leave kicks in. I realize this can be confusing and complicated for people who haven't dealt with it. California Family Rights Act leave provides for 12 weeks of bonding leave after the up to 4 months of pregnancy disability leave is over. So it's up to 7 months leave in California for a pregnant employee who then needs bonding leave, in contrast to the federal 3 months. This is a big difference. And then there are state disability benefits that come into play, and they consist of SDI, which is state disability insurance, and paid family leave. Anytime you have a California pregnancy leave issue, as is the case elsewhere too, you're going to be needing to look at the laws and the regulations to make sure that you're not running afoul of them. Now let's look at parental leave, which is different. It's for an employee who has not had a pregnancy, but that, Sam, next slide, but that employee who's not had a pregnancy nonetheless has rights under the California Family Rights Act. That employee gets up to 12 weeks to bond with a child, including an adopted or foster child, within the first year. And CFRA, California Rights Act leave, runs concurrently with federal FMLA. So this is different. This isn't the 7 months for pregnancy. This is the 3 months like federal family and medical leave. In addition, there's a Family School Partnership Act, which provides for up to 40 hours a year for childcare and school activities. There's a state benefit paid family leave. And then one must consider the paid sick leave rules, which are both state and local, which come into play for pregnancy and bonding. Paid sick leave is another complicated arena across the country with a patchwork of state and local laws and a whole variety of legal obligations. So many things to consider in the state and local arena, using California, which is likely the most complicated, as an example. Let's look at a hypothetical. The work performance of a California employee is poor. The company terminates the employee with a brief letter stating some reasons for termination, and there are reasons stated that are related to work performance. It's documented, but absenteeism is briefly mentioned in one sentence. The employee has a child with a medical issue. Are there any possible claims? This is a real scenario. This was a California employer with employees in San Francisco who was sued on this fact pattern. So, what comes into play here? This is a family caregiver discrimination scenario. Let's look at the next slide, Sam. There was a California bill to prohibit family caregiver discrimination vetoed by the governor in 2023. Again, still California. Senator Booker has introduced a federal bill to prohibit family caregiver discrimination, but the employee whose status led me to write the hypothetical was in San Francisco, which is governed by the Family Friendly Workplace Ordinance, which bans discrimination against family caregivers. Now, I'm looking at this slide and I don't see yet another similar statute or ordinance. There may be one, but this California Family Friendly Workplace Ordinance banning discrimination against caregivers is relatively unique. It covers employees who work at least 8 hours a week in San Francisco, whether remotely or on site, and employers who employ 20 or more anywhere. So family caregiver discrimination will be a developing area of the law, given the efforts to expand protection in this arena. There are many local laws in the landscape of pregnancy and parental leave beyond the scope of a brief seminar, as we see on this slide. So note, some of the most protective jurisdictions are New York and DC, in addition to San Francisco. I always look at Illinois too when employers ask me, what are the states of most concern? Well, among them are California, Illinois, New York, DC, Massachusetts, etc. There are a patchwork of laws covering private employers, various paid leave laws, various state disability benefits. In some states, the reliance is on the FMLA and other federal statutes. In other areas, state and local laws much more protective and must be taken into more significant account. So always check for applicable state and local law when presented with pregnancy and parental leave requests. And one additional note regarding policies and practices and rights regarding short-term disability. So many companies offer short-term disability insurance that provides partial wage replacement for work missed due to a disabling condition. Some states maintain state-administered disability benefits programs. Employers often incorporate short-term disability into their short-term disability insurance policies into their pregnancy and parental leave policies. For example, leave may be unpaid or partially paid, but the birthing parent can apply for short-term disability for the period when unable to work. In some states, doctors typically certify at least 6 to 8 weeks. However, for example, in California, where state law allows for 4 months of pregnancy disability leave, doctors often certify the full 4 months for disability leave purposes. This is really up to the doctor, and I can tell you that in some states, doctors routinely will certify a substantial amount of pregnancy disability leave, even though the reality is that if someone had to come back to work, they might be able to. Doctors are accommodating to pregnant employees and will often certify a larger amount than you might expect. So check for both state and employer disability entitlements when an employee needs a pregnancy disability leave. In addition, the impact of all types of employee benefits is always to be taken into consideration in administering a disability leave, whether state administered benefits or employer paid private insurance benefits, such as a short-term disability leave policy. Thank you.
Thanks, Sandy. That was a lot of information about state and local law. And I think that is one of the biggest takeaways from this presentation, is you have to understand the very bare minimum that you have to offer. And you have to make sure that you are looking at states where you have employees, not just where you're based. So we'll talk a little bit more and leave you with some tips and practices, but I think the state and local leave piece is really, really significant. And I think one of the biggest things we want to impress on the group today. So just some final thoughts here and just some trends that we've seen. I talked a little bit before about primary versus secondary caregiver model. And like I said, that has been a very common way in the past of developing policies, and especially because it's often because employers want to offer more than what they're required to under the law. They want to offer paid leave even in situations where they don't have to, or they want to supplement those disability benefits that Sandy just talked about. So it's very often well-intentioned and no ill will, but because of the trickiness of complying with Title VII, complying with FMLA, all those other pieces, and then that state and local law, at least in my experience, and Sandy and Ann, please feel free to jump in, I've been sort of seeing a movement away from the primary versus secondary caregiver model, and moving away from terms like maternity leave, paternity leave, as well, just because there tends to be sort of either a discriminatory connotation or a discriminatory impact of those kinds of policies. Policies also sometimes inadvertently exclude same-sex couples. They often inadvertently exclude adoptive and foster parents. And so as we move towards or away from the primary and secondary caregiver model, I've been seeing a lot more examples of policies that are more inclusive in nature, that sort of grant these, these general blocks of paid time for new parents. And so I'm going to hand it back to Ann, and if you wanted to provide a little more insight on that.
And that's right. And that I absolutely concur. That is, I think, what I've seen in my practice. I think that's been a large shift for those reasons. And kind of looking at, the equal bonding leave for new parents, then that is, not discriminatory towards anyone, based upon gender, based upon, if they are a same-sex couple, et cetera. And it also can, apply regardless of whether the child was, given birth to just then, or if the child is coming to the family, through adoption or foster care. And so I think, looking at what is the actual reason for the leave, and kind of, I don't know if the FMLA gets credit for this or not, but there are different types of leave under the FMLA. There's the medical piece, and then there's, the care and the bonding piece. And so really parceling out what is the reason for it. There are, having given birth myself, there are medical reasons for you to be off after doing so. But then there are, those bonding reasons or if you need to, for example, under the FMLA, if you need to take care of your spouse, your child, et cetera. So I think really looking at what is the purpose of the leave and, kind of peeling back those layers instead of just thinking maternity leave after a baby's born, that's what it is. There are a lot more pieces to that. And I think, that helps us really distill down what is the reason for it and how really gender, sexual orientation, et cetera, doesn't play into that at all. And I think that can really be helpful. And so as noted on the slide, policies distinguishing between those reasons, as long as they're, legitimate reasons, that's what really does help make sense. It may add something for men, which, in one of the scenarios that while that can be a little concerning maybe on the front end as the employer is looking at the bottom line, but that also, I think in the long run really helps, take away from, the stigma for women as they are expanding their families in the workforce. And so I really think in the long run, it's an equalizer and helps us all. Sorry, Sandy, go ahead.
Yeah, to comment on that, the terms primary caregiver and secondary caregiver, in my view, are out of date and should not be used today. They're ambiguous, and frankly, I think it's discriminatory. So we need to move away from primary caregiver and secondary caregiver in our policies, and that's my recommendation.
I'm actually going back to this very quickly. And Sandy, I think you're not alone. There's actually been a lot of litigation on this too. It's not necessarily that primary versus secondary caregiver is inherently discriminatory, but as mentioned, so that there's a pretty notable case involving a large bank that it was a $5 million class action settlement involving their primary versus secondary caregiver policy that had to do with the fact that birth mothers were treated as the presumptive primary caregiver, and then any other type of parent who wanted to be treated as the primary caregiver had to kind of go through all these extra hoops to kind of prove why they were going to need to be the primary caregiver, which necessarily had an impact on men. But it also, to Anne's point, in many ways, that's not a beneficial policy to women either, because if men were, adoptive parents, foster parents, same-sex families, whichever parents want to step in and be primary caregivers, it's really difficult to have a policy where the employer is the one to sort of decide that or be the final call. And it doesn't help anybody in the long run. So yes, I just wanted to call out that has been litigated and that has been settled. And so if you need any more reason to want to revise your policy, that's a pretty compelling reason.
Well, this is where state law comes into play again. I was on a seminar this week where one of the attorneys speaking was from Washington State, and he said the employer always loses. And what that attorney meant was that the laws are interpreted in certain states extremely liberally in favor of the employee. So primary caregiver versus secondary, what state you're in may have an impact there too on how your policy is going to be viewed.
I also think it's kind of ambiguous. I mean, having my kids are a little bit older now, but still, I mean, it depends on the day. It depends on the week. I mean, between who's primary, who's secondary. And I mean, so I think, I think there's a lot of good reasons to move away from that.
Yeah, well said, Anne. I think that makes the point.
Okay, so just to close out, and we might have a little bit of extra time for questions, but just some last minute tips on how we would recommend going forward, given PWFA and some of these trends that we're seeing. I think most importantly, from my perspective, is make sure that your HR and your supervisors are aware. Make sure that your policies are updated to reflect pregnancy-related accommodations. That's one thing that I've been seeing a lot when I review handbooks or policies, things like that. This is new. This is sort of a watershed type legislation that we have to update our reasonable accommodation policies. In some cases, we have to update our pregnancy and parental leave policies and make sure that everybody's trained on it and make sure that people are listening out and observing and being aware of when that obligation to accommodate pregnancy or related medical condition kicks in. Like ADA, like FMLA, there's no magic words. They don't have to come to you and say, I am pregnant and I need an accommodation. There are other ways that employers are expected to understand. And we haven't talked about this a lot, but there are also some unique documentation issues involving PWFA that also makes it a little bit distinct from the ADA. And so if you have any questions about that, you know where to find us, but just to be aware and make sure that your policies and your documentation is updated. Similarly, like I said, when you're crafting your parental leave policies, just consider where PWFA fits in and state and local law, to Sandy's point. FMLA is the backbone. It's often the bare minimum, but there are pieces on the beginning, pieces on the end. Additional leave may be required. When Sandy was talking about local law, for example, I believe it's New York was the first state that actually just passed a prenatal leave law that's an additional bank of time just for prenatal appointments. And so it's just really important to be aware of where you have employees and how that might impact your policies. I also just want to say that I think it goes a long way to proactively help your employees understand their options. One, because it's the right thing to do. It's very confusing if you're an employee, especially I've never gone on pregnancy leave or parental leave. But I know people who have, and I know it's a really confusing time figuring out how much leave do I have? When does it start? When do I have to come back? What paperwork do I have to submit? So to be proactive, it's not only a really positive benefit for your employee, but it also just helps to sort of mitigate risk of doing something wrong or people not having the right notices as required under law. So anything you can do to be proactive, I think, is helpful. And emphasize, your remote employees are covered by the state laws where they live and work. And even if you have one random employee in California or Connecticut that you're like, oh, well, yeah, we just have the one remote employee, make sure you are aware of potential leave entitlements that they have and make sure that they have all the required notices on time. So that is something that comes up a lot. And actually, since we have a little bit of time, I have a question myself that I would like to pose to Sandy and Anne, if you are willing and able to answer. I'm curious how you handle sort of multi-jurisdictional employers and policies. So Sandy, you're in California. I'm sure you have employers that you work with that have clients all over the place. What do you recommend as far as customizing pregnancy and parental leave policies when there's so much variety between the states?
We determine how many employees are located where, and then we have a dialogue with the employer about whether the employer wants consistent policies that comply with the most protective rules across the country or individualized policies. So if the employer is in Pennsylvania and is in other states where Pennsylvania is sufficiently protective, you might have an employee handbook and then a supplement for California and any other state where the rules are more stringent. But it's always a dialogue with the employer based on where employees are located about where the employer wants to go with the policies and how protective they should be overall. Will you have state supplements? And Sam, I'll have some other comments if we have a little more time.
Sure, absolutely.
And that's exactly what I do too, Sandy, is we figure out what does the employer want to do, as far as, compliance. Do they want to be most protective? Do they want to be, how do they want to handle this? And some of that it's not that they don't want to be protective, but it requires a lot of administration. And so, but it also can be a lot of administration to have separate pieces too. So kind of weighing all of those interests and figuring that out. And then usually we end up with, some level of state supplements to handbooks.
I think policy drafting is extremely difficult. Ideal often with employee terminations, sometimes really delicate ones. Policy drafting is equally difficult, in some cases, if not more difficult, if you're in many jurisdictions. And as we get more and more state and local laws, it just gets all the more difficult. A couple of points and then a slightly different but related topic. So with respect to, Samantha mentioned the needs of the individual employee. So consider the unique circumstances of that person. And I realize if you're a general counsel, if you're the chief HR officer and you have people reporting to you who do this work, you may not be doing it yourself, but someone has to consider the unique circumstances of the person. And what documentation will you provide? Will it be standard, or in this particular case, does it need to be tailored to the unique circumstances? And then often we're called upon, can we terminate this employee who is or has been on pregnancy or has taken some other protected leave? And some of my questions and answers involve the following. Will the action to be taken look fair, or will it look like the leave is a contributing factor? Would the same action have been taken absent the leave? I work with clients in preparing termination letters stating the company's business reasons for termination with some specificity. I'm a believer in termination letters, telling the employee the reason for termination. I've had people say in response, oh, we might not be able to put everything in. It's easy to pick at that later. I'd rather not tell the employee in the writing the reasons for termination. In my experience in states very protective of employees like California, New York, Illinois, etc., a termination letter goes a long way toward protecting the employer against litigation. So what I'm recommending is documentation supporting the non-discriminatory business reasons for termination. Why is this employee being terminated? What are the work performance reasons, or what are the conduct reasons? Sometimes it's both. And that documentation, which I certainly recommend in California, is there so that the employee knows that the employer was fair, and so that if the employee goes to a plaintiff's attorney and the plaintiff's attorney asks, what did they tell you was the reason you were terminated? The employee has to hand the prospective attorney a termination letter, and then hopefully will think that a legal challenge will not be productive. I had a situation where a client was insistent on terminating someone who was on disability leave, essentially for the absence. But we wrote a letter that dealt with the inability to reasonably accommodate, etc. It was a pretty good letter. The employee did sue, and ultimately we won on summary judgment, in large part based on the letter. So that documentation, the documentation when the employee is working and the documentation when the employee is terminated, is very important. And I say this not to be harsh, but knowing that many of you on this webinar will be thinking at some point that you need to terminate an employee, but that employee has had a protected absence. The way to do this is to be fair, to document why you're doing what you're doing, and to follow the golden rule, which is to treat the employee as you would want to be treated yourself.
And I don't disagree with that at all. I mean, I know, I think the concern that folks have is, the termination letter is not written well, or there's something missing. And, and in particular, if there's something missing that, if someone's deposed or on the stand, they're going to say X, Y, and Z, then that looks like it's shifting reasons, and is it pretext, and was it really discriminatory? But I do think, a carefully drafted termination letter can be helpful, because like Sandy said, they take it to their lawyer. Well, did you do this? Well, yeah. Did they talk to you about this? Yeah. I mean, I think that can help. But again, we want to make sure that, we're careful with, making sure that we've got the reasons in there and how that's articulated, again, just to make sure that we're not, that it's not going to be exhibit A for, oh, this was actually pretext and the real reason was discrimination, that sort of thing. But I do agree with you, Sandy. I think it can be very helpful, especially in a sensitive situation like that.
Well, in addition, we're often asked for a script of what to say to the employee. And my answer tends to be read the script, right?
Yeah.
Because we've worked through the non-discriminatory reasons for this termination. And so that you know what they are because we've written them.
Exactly.
Okay, well, any final tips and takeaways for our participants today? No. All right. Well, Sandy and Ann, I really appreciate your practical insight here. I think that is that's one of the biggest challenges with the pregnancy and parental leave framework is not so much understanding the basics of the laws, but understanding how to implement them in the best way for the benefit of the employee, but also in order to protect the employer, especially where there's so much potential liability out there for those protected leaves of absence. Anytime somebody engages in a protected activity, which is typically not the reason for termination. Typically, there's a legitimate business reason, and just looking out for the company, the employer. Okay, so with that, I think we do have a couple of minutes left. I don't know if I'm not able to see the chat. But if somebody else is able to read I think there was a question in there.
One other thing while we're looking at that, I do think sometimes employers get a little paralyzed when they're dealing with an employee that has, protected status, protected leave, which is a protected activity. And then things sort of shut down. And it shuts down from the standpoint of documentation and moving forward and managing the employee. And that's not the right answer. It's non-discriminatory. You don't want to treat people differently. So, just kind of keeping that in mind, understanding that there are, going to be some different, stickiness to it potentially by, potential claims that someone could raise because of that. But it should not completely paralyze an employer or manager from managing their workforce.
Since we have a minute, one final point that I think about, employees do have rights under disability policies, and in taking action vis-a-vis an employee, when appropriate, I check to make sure that, let's say, by a termination, I'm not denying an employee some rights under a disability policy. And that's unrelated to much of what we've discussed thus far, but there are always factors like this that as employment practitioners, we think about as we go through the process of working through these issues.
Thanks, Sandy. Okay, well, actually, now with that, we did have more tips and takeaways. So we are coming right up on the hour. There have been a couple of questions in the chat. We will get back to you offline later today. And thank you all for participating in today's CLE webinar. You will get a link in about 30 business days to your CLE certificate for those of you who have signed up for CLE credit. Your webinar login details will be used to process these certificates, so no additional steps are required. And just as a reminder, the code word requirement was only if you are seeking credit in Kansas, New York, New Jersey, or Pennsylvania. So with that, thanks again, everybody. Have a great rest of your day. And if you have any questions, feel free to reach out to any of us on the panel or to our business development team. And their emails should all be available on the communications about this webinar. So you should find somebody to get in touch with if you need. Thanks again. Have a great rest of your day.
Thanks, everyone.
Thank you.